My Lord, two matters arising out of questions posed by the court before the short adjournment. First, although the transcript revealed quite clearly, as one would expect, that the case of Harris was relied upon by the present appellants before the Court of Appeal, it is not, in fact, contrary to my impression, referred to at all.
Well, I couldn't see it, but
Your Lordship is quite right. And secondly, in relation to the issue, does it matter if reasonable foreseeability is in place only in relation to the proviso and not in relation to the substantive obligation? At the moment, we accept burden of proof is the key issue, and we haven't been able to differentiate any obvious alternative way of saying it does matter. What I've been addressing, I'd made the submission before the short adjournment that the Court of Appeal, and I'll show you the passage in a moment, appeared to define safety as being something that can be identified once and for all time. And we say there are four reasons why that should not be the proper approach. The first is that there are few, if any, areas of human life, in particular industrial life, where risk could be wholly eliminated. And for something to be less than safe does not mean make something safe does not mean that one has to make it wholly risk-free. Secondly, that knowledge of risk changes over the years. Some risks are perceived to increase, others to recede. Thirdly, and perhaps more importantly, although a risk itself may not change, society's attitude to that risk may well change over time. And fourthly, we would say, in its ordinary and natural meaning, at least one of the cases referred to by my colleagues vouches for this, the concept of safety does have a qualitative connotation. It is a matter of opinion and not simply measurement, whereas, for example, if the obligation is to keep equipment in efficient or a state of working order, I mean, either the machine works or it does not work. That has, as it were, a measurable connotation. I just want, if I may, to take your lordships in support of the first of those four propositions to the speech of Lord Hope in a case in which there's a debate at the bar whether it should be called Queen against Chargot or Queen against Chargot to rhyme with escargot, but given that it is an English company, we have tended to assume that the former is, alas, the position. This is, whatever be the correct pronunciation, and none of my lords were, alas, part of the committee in that case. Volume 6, tab 95. And this, in fact, was a first time I think the House had had to consider the Health and Safety at Work Act, which, of course, implemented the Robin report. At paragraph 12, one sees the relevant provision, quoad employers. This is at page 6. It shall be the duty and of every employer to ensure, so far as is reasonably practicable, the health, safety and welfare at work of all his employees. I point out, and I've already made the submission, that health and welfare are there added specifically to safety in the same provision. It's also important to note that the verb of the obligation is to ensure, which in our respectful submission has more stringent connotations than the words keep in the section 29. Then going forward, at 14, one sees an obiter analysis of section 29(1) of the Factories Act, where they say onus of proof of compliance, and the Lord Hope introduced it with his 4 lines in the end, with any duty or account is qualified by those words on the defence. Those are the words reasonable practicability. And then he illustrates that as being a factor or feature of section 29(1), and then he refers to its repeal, and he refers to the important case of Nimmo, in which by a 3-2 majority decision only, the section was construed as imposing the burden of establishing the defence upon the defendant employers, Lord Reed and Lord Wilberforce, being in fact in an important minority. Then at 17, he refers to the scope of the duties as being the word to ensure. He asks the question, what is he to ensure? Is he ensure health and safety, etc.? And then he goes on at the foot of that paragraph, at the next page. The duties are not, of course, absolute, qualified by the words so far as is reasonably practical. If that result's not achieved, the employer will be in breach of the statute unless he can show it's not reasonably practical for him to do more than was to satisfy. And again, at 18, he, at the last three lines, makes clear, by reference to section 29(1), is that this is an obligation to achieve a certain result. But I just pause there and say, we, of course, accept that in relation to section 29(1), but it doesn't answer the question, what is the result to be achieved? And perhaps the most important paragraph from that perspective is paragraph 27, in relation to the concept of proportionality, and bearing in mind, incidentally, as is clear, that the Health and Safety at Work Act was meant to enlarge protections that had previously existed for the workforce. And under the rubric proportionality, Lord Hope says this: the question then is whether this approach to legislation is proportionate. The first point to be made is when the legislation refers to risks, it's not contemplating risks that are trivial or fanciful. It's not its purpose to impose burdens on employers that are wholly unreasonable. Its aim is to spell out the basic duty of the employer to create a safe working environment intended to bring about practical benefits, bearing in mind this is an all-embracing responsibility extending all workplace people in all working circumstances. The framework which the statute creates is intended to be a constructive one, not excessively burdensome. He then refers to a tragic school case, and then 4 lines from the end. Having said its exception of that paragraph, it makes an important point. The law does not aim to create an environment that is entirely risks-free. It concerns itself with risks that are material. That's in effect what the word risk which the statute uses means. It's directed at a situation where there's a material risk to health and safety which any reasonable person would appreciate take steps to guard against. Now, we of course recognise and indeed aver that one has to be very cautious about reading across from legislation phrased in one way to legislation phrased in another, even in a cognate area. But what we can say with some confidence is, given that the Health and Safety at Work Act was intended to enlarge employees' protection, the fact that Lord Hope considered that proportionality was a tool of construction must be a fortiori in respect of the earlier legislation. And we say then that in its ordinary and natural meaning of safe must involve consideration of what is known or ought to have been known at the time to be dangerous. And if the meaning is to be extended to include dangers that were unknown at the time, but which became later known only through greater knowledge, then of course no workplace could ever be said with certainty to be safe. And
but you say that applies under Section 2 of the Act, of the 1974 Act as well?
Well, no doubt, but all I'm doing is...
But surely that, to date, surely this has been construed as being an absolute obligation to ensure, though to ensure that it's risk-free.
Yes. Well,
there's no jurisprudence which suggests that you bring in some notion of reasonable foreseeability, is there? In the context of Section 2 and 3 of the...
no, there isn't. But there is the idea that there is...
On the contrary, you wouldn't have to direct the jury. Well, you just have to say, well, members of the jury, all the prosecution's got to show is that the defendant failed to ensure that his employees were not exposed to the risk of...
Failed to ensure, which I say is equivalent to guarantee. But what Lord Hope does say is this doesn't mean it has to be risk-free. That's a distinction you draw.
Wouldn't you have to direct them also that fail to ensure so far as is reasonably practical?
Yes.
No, you wouldn't, because that comes in only at the defence stage, doesn't it?
Well, under Section 3 it appears to be part of the offence.
Well, I'm not sure about that.
Well, this is quite an interesting debate, but I mean, no doubt, on the assumption that argument was advanced on the basis it wasn't reasonably practical in any event, a jury would have to be directed to both limbs.
Yes.
And no doubt they would be said, they would certainly be told that the onus of establishing reasonable practice.
The only thing I raise is because, I was myself once involved in one of these cases, and I thought the position was on the authorities that there were two stages, that the burden is on the prosecution to show that the exposure to the risk, and once the jury was sure about that, it was over to the defence to show, on the balance of probabilities, that the defendant had taken reasonable precautions.
Yes.
That's how the sections have been held to fit together, I think.
Yes, but I'm not with respect disputing that. I wasn't relying on it for that particular purpose. All I was saying is that even under the 1974 legislation, a distinction is drawn between something that is insured to be health and safety and welfare at work. That's the duty. Qualified by as reasonably practical. It doesn't mean that you are obliged to create an entirely risk-free environment.
Mr. Beloff, I noticed in the last sentence of paragraph 27,
Yes.
Lord Hope, having said what risk means, he said it is directed at a situation where there is a material risk, which any reasonable person would appreciate.
Yes, and take that.
Well, isn't that talking about reasonable foreseeability?
Well, it's, yes. I would say that is not a synonym for, but it's the same
But I mean,
approach.
that supports you, doesn't
That
it?
does support
if
me.
we're looking at this by analogy.
It supports you even further. I say that if an act which enlarged employee protection is to be construed in that way, a fortiori, an act which was more limited must be construed in that way. That's a submission. And it may be that I have not only the fact that risk-free is not to be equated with ensuring health and safety at work, but also that the last sentence suggests that reason for foreseeability, or not merely perhaps reason for foreseeability, that it is something that you would both appreciate and take steps to guard against. So appreciation may be evaluative, but certainly it's got to be reasonable to take steps to guard against it. But I'm not rejecting the possibility, or indeed certainly not rejecting the observation that reasonable foreseeability might be thought to be intrinsic on that analysis to the Section 2 of that Act.
But if the words "so far as is reasonably practicable" were not contained in Section 2, subsection 1, do you say that it would still only be necessary for the employer to take such steps as were necessary, as a reasonable person would appreciate were necessary?
Yes, I do. That is the submission we make.
Well, it does seem a gloss on the ordinary meaning of the word "ensure," doesn't it?
Well, it may be a gloss on the meaning of the word "ensure." We're not actually, I mean, even if that were so, we are not here concerned with a statute which has a obligation to ensure. It's to be make and keep safe, which, in our respectful submission, is a lesser obligation as a matter of ordinary parlance. In any event, I mean,
I just wonder whether Lord Hope, in giving that explanation, was including the rubric "so far as is reasonably practicable" in his overall evaluation of the nature of the duty.
If he was, he didn't say so.
No, he didn't.
At that juncture. And Lord Hope, say so with great deference, a person noted for his precision. Can I just state, I mean, what we say is the judge was against those observations. The judge was right. The Court of Appeal were wrong. Can I just show you what the Court of Appeal said? They said in their judgment, at paragraph 77 to 78, the judgment of Lady Justice Smith, Core Bundle, Volume 2, Tab 3. I'll come to what the judge said at paragraph 79 because he simply accepted the observations of Mr. Justice Rose, as he then was in a case called Taylor and Fazackerley. If you go then to the judgment of the Court of Appeal, you see how high Lady Justice Smith appears to put the matter.
Paragraph
77. just you will see that the judge whose decision was being in the course of being overruled, the judge's summary is to be found at page 50, paragraph 52 of the Court of Appeal's judgment. And you see that he was there following a judgment of Mr. Justice Rose in Taylor and Fazakale, where he said the question whether a workplace of work is safe is really a jury question to be answered in the light of all circumstances prevailing at the time, including what might reasonably have been foreseen by the employer. And then one sees, then after protracted analysis of the intervening authorities, what was said at 77 is a rejection of the intrusion of the concept of reasonable foresight into the notion of the obligation to make and keep safe a place of work. And then what is said at 78, I accept Mr. Hendy's first submission that what is objectively safe cannot change with time. If 85 dBA lequa causes deafness to a particular claimant, that claimant's place of work was not safe for him or her. It might have been safe for another person working alongside. Already one has, as it were, a divorce, safe for some but not safe for others. But for the susceptible worker who has in fact been damaged, it can be demonstrated without more, his or her place of work was not safe. Looking at the point of view of the workforce generally, so she's now looking at it not just as the susceptible worker, but the workforce generally, it is known that a minority of people will suffer appreciable harm as a result of prolonged exposure to 85 dBA lequa. Therefore, it can be said the place of work is not safe for the workforce because there is a risk of injury to all of them. Some of them will be injured, but not all. No one knows which of them will not be injured. They all face some risk, save for those workers who are already known to be of average susceptibility. For those reasons, I'd hold on the evidence before the judge, not controversial, place of work where the ambient noise levels were 85 dBA were not safe. Now, what Lady Justice Smith appears to be saying, not only that a place of work can be simultaneously unsafe for some, but safe for others, but that if a place is unsafe, judged by that standard, for any single employee at any time at all, then it must be unsafe within the meaning of the statute for all employees at any time, at all times. So that would be so even if the following criteria were not satisfied. One, science had not even identified the danger. Two, the employer was reasonably unaware of the risk from that danger. Three, the employer was reasonably unaware of the susceptibility of any particular employee. Four, the employer had no means of ascertaining that particular sensibility. And five, the employer had no means of predicting for how long employees in his employment would be exposed. And we respectfully submit it is quite fanciful to believe that the legislature required so volatile a standard. The fact of the matter is, my Lord Mance pointed out during the course of argument for the adjournment, in the area of injury by noise, if that's the appropriate vocabulary, it results not of a one-off event, a rung on a ladder collapsing or something of that kind, but from two additional factors. One, the length of time to which one is exposed, and two, whether one is peculiarly susceptible. And in our respectful submission, that shows why the moment one detaches oneself to what we say is the proper, if limited, interpretation of the concept of safety of the place, one is going down a path which the legislature did not intend one to go down. Now, just pausing on the issue of reasonable foreseeability at this juncture, We've also set out, and this itself is not controversial, that there are two streams of authority as to whether what is meant by safe in section 29 subsection 1 does embrace itself the question of reasonable foreseeability before one ever gets to the question of reasonable practicability. The notion that it does is set out in the cases that are listed in our written case at paragraph 106. The notion that it does not are those which are listed in our written case at paragraph 107. The last or penultimate one of those cases, a decision of a two-judge court of appeal in Lana, was a decision that the Court of Appeal felt in any event bound to follow because it was a decision of a court of equivalent jurisdiction. We've sought in our paragraphs 124 through to 128 to suggest a number of reasons why the analysis in Lana is wrong, and we've also paid tribute in the same critical way to a subsequent decision of the Court of Session, the lower house, called Mains and Uniroyal, which also espoused the Lana analysis. We've dealt with that at paragraph 130. But in any event, the main point in relation to Lana was the collapse of the structure under consideration in that case was reasonably foreseeable, making all the observations made subsequently obiter. Now, we are of course aware the Supreme Court is not going to be impressed by questions of quantity, but rather perhaps of quality. And if I may, I want to restrict my citation to 4 cases, because we say it's the reasoning in those cases by judges of the highest pedigree that should impress the Supreme Court. And the first of the 4 cases is the starting point at the House of Lords of this line of authority on which we rely, and with all the caveats that one makes that they were not construing the identical section, in our respectful submission, the way in which they analyse the concept of safety or danger in the same legislation is highly germane. Can I ask you, it's volume 4, tab 60. Now, this is the passage that we rely on in particular is the speech of Lord Reid at page 765 through to 766. And this was where what was being construed, as you see from the head note, was that part of the Act which referred to dangerous machinery. Every dangerous part of any machinery shall be secured unless it's in such a position or such construction as to be safe to every person employed or working on the premises as it would be if securely fenced, forgive me. And at 765, some 8 lines on the foot of the page, 7 lines on the foot of the page, Lord Reid says, the mere fact that such an accident occurred is not enough. The question is whether before the accident it was reasonably foreseeable that an accident of this kind might happen. And it's worthy of note that although it's suggested by my learned friend, Mr. Hendy, that Viscount Simmons took a different approach to that of Lord Reid, if you go back to 750, you will see that Viscount Simmons introduces his own speech with the words that I've had the privilege of reading the opinion which my noble and learned friend Lord Reid will deliver, and am so fully in agreement with it that I propose to make only a few short observations myself. Now we say to like effect, one sees the speeches of Viscount Simmons himself. I just give you the references, bearing in mind the time, at page 753, and Lord Keith at page 774, both of which espouse a test which incorporates a test of reasonable foreseeability, as did Lord Reid himself. And it is worth noting in this context that in Allen and Avon Rubber, which is a case that my lords have in the bundles, a case of the Court of Appeal, decision in 1985, Volume 1, Tab 2, Lord Justice Stocker, who was there giving the leading judgment in a case which actually involved Section 29(1, and as whom, as my lords will know, was highly experienced in this area, considered the approach of Lord Reid, which I've just given to my lords, as he put it, to be as apt in respect of a place of work as it is to the safety of a machine. And in Taylor and Fazakerley...
Sorry, you're going very fast. That's
I'm
page
so sorry,
703.
I'm very sorry.
But where do we...
Volume 1...
Yes, I mean, the passage in Lord Justice Stocker is page 703 at E.
Yes.
But where do we find, I mean, these are obviously come from very high authority, but where do we find any analysis? Are you going to show us a passage in which the rival interpretations are considered and analysed?
Well, they are considered in Lana and in Maynes in particular, and we've dealt with those in our printed case.
But you said you were going to show us four authorities. Which
Yes.
I thought we were going to find some analysis. We're not. We're just going to find assertions, are we?
Well, it depends what you mean by assertions. I mean, this is analysis. I mean, that's what they say. Which means perhaps the next passage I'll come to of Lord Justice Diplock in Taylor and Coalite may come a little bit closer. But can I just say this? Allen applies the reading of Section 14.1 to Section 29.1, which my lords are concerned. And Taylor and Fazakerley is still closer to the point, because that's Mr. Justice Rose. This is Volume 6, 109, at page 10 of his judgment, exactly the same test for noise at work under Section 29.1. And having, in a sense, already, as it were, contradicted our primary positions about whether place embraces noise, just assuming we're wrong about that, at any rate, as far as safety is concerned, what he said is, and I'll just quote it if I may to you, because it was the sheet anchor of just His Honour Judge Inglis's judgment, did the defendants, by reference to standards which ought reasonably have been adopted by them at the relevant time, expose the plaintiff to noise which they ought reasonably to have anticipated, would or might, by reason of its level or duration, damage his hearing. So there one has Reid applied both to Section 29.1 and more specifically to 22.
But is this point discussed in any of these cases?
Well, it depends what one means by discussed.
Well,
I mean, this is, yes.
as my lord says, was the point we're now considering debated on either side of the argument in these cases, including Miss Justice Rose's case?
Well, I'm assumed that, yes. And can we just check that? I mean, I have assumed the point didn't go by default. Because there were, we'll just check that if we may. Maybe those of my learned friends who are coming after me will just check. I'm afraid I've assumed that nothing is said it was by concession.
No, I don't think that was the point that I was...
No.
I wasn't assuming that it had gone by default. I was really looking to see whether there's any analysis of the pros and the cons of the two different interpretations.
Well, what we say is that you can justify the propositions that were espoused in the House of Lords in Frost and Summers on the basis that Parliament cannot have expected an employer who could not reasonably foresee either that a piece of machinery or by parity of reasoning a place of work was unsafe to take necessary precautions, especially when the duty is subject to the identified exception, a result-orientated duty. I mean, how does one ever get to the stage of considering reasonable practicability if one neither could nor should have recognised that the place of work was unsafe? It simply makes meaningless the proviso or the defence.
If it comes in at the reasonable practicability stage, then you don't need it at the prior stage.
Well, it's been dealt with by Lord Gough in a speech I shall show, my lords, and I'm going to show you, Your Lordship, why I consider with great respect that Lord Gough really doesn't focus actually on the full implications of postponing it all to the stage of reasonable practicability. In other words, as my law puts to me provisionally, taking it out of the category safe and into the category reasonable practicability, and that's its only location. I'll come to that if I may, because I'm seeking to do this sequentially. Lord Justice Diplock in Taylor and Coalite at 6/108, Vol 6, tab 108. And this is yes, much obliged. It's the same one as Chargot. This is a 29-1 case, but a reasonably practical, the means of access rather than place of work. Now, at 319, Lord Justice Diplock says this, because, of course, there had been an issue as to whether the accident occurred in access to the place of work or to the place of work. One of the reasons why Parliament, it may be belatedly, had to add in the second part of the clause of section 29.1. And what Lord Justice Diplock says is, even if, however, the place where accident occurred was the plaintiff's working place, we do not think the result would be any different. The occupier's duty in respect of working places is not to prevent accidents occurring to persons working at them, but to take all such measures as are reasonably practicable to make and keep the working place safe for such persons. Safe is the converse of dangerous. A working place is safe if there is nothing which might be a reasonably foreseeable cause of injury to anyone working there, acting in a way which a human being may reasonably expect to act in circumstances may reasonably be expected to occur. He then refers to a passage in Lord Reed's speech in Summers, and we say with respect he is simply using, as it were, the ordinary concept of safety in the context of that particular statute. In determining, he goes on, therefore, when the occupier was under a duty to take any measures to prevent an accident which was caused by the presence of the working place of a particular object, it's necessary to ask, first, whether the possibility of the object being at that particular place was reasonably foreseeable, and secondly, whether it was reasonably foreseeable that it would be a cause of injury to a person working there. It is only if both those questions are answered affirmatively, so that's, as it were, at the make and keep the working place safe, that it becomes necessary to consider whether it was reasonably practicable to avert the danger. And in our respectful submission, again, Lord Justice Diplock is not only using what we say is an ordinary use of vocabulary in context where, as he noted at page 318 at the top of the page, we are concerned with a statute, the breach of the relevant provision of which engages criminal liability. So it may be that that simply reinforced what he thought was the ordinary and natural meaning of the words, and it is abundantly clear, whether your lordships were to find it right or wrong, it's abundantly clear as far as Lord Diplock was concerned, the issues of foreseeability and indeed reaction are engaged before one ever comes to the, as it were, matter which the onus of which lies upon the defence.
But is it the ordinary and natural meaning of the word safe to say safe means what I can reasonably foresee is safe? Surely safe means something that doesn't carry a danger. That's an objective measure rather than something that is subjectively to be predicted.
It's not something that, in our respect, can actually be measured. What someone considers to be safe in circumstances is a matter of judgment and opinion, and that's why there is the ability to construe it in that particular way.
But if I'm employed in a place where I suffer an injury as a result of the activities of my employer, does it not follow, as a matter of logic, that I have not been employed in a safe place?
Well, we say not certainly in these statutory contexts, and not obviously as Lord Justice Diplock thought,
No,
because
quite.
he considered safe was the converse of dangerous.
Yes, well, all that I'm asking at the moment is whether it is the ordinary and natural meaning of the word safe, or whether, as Lord Justice Diplock, to my mind, seems to be saying, that safe has to be given a special connotation in these circumstances.
Well, my first answer, my Lord, which is sort of repeating what I've said, is we do say that there is a measure, although it is an objective standard, nonetheless there is an element of opinion in it, objective by reference to what tests does one look with the benefit of hindsight in relation to matters which one simply could not have known at the time, or is it contextual in that particular sense? If the Court of Appeal is right, your Lordship's chamber may, at the moment, be considered not merely to be elegant, but wholly safe. It may be discovered, who knows, in future, that the mobile telephones and BlackBerry, which mercifully have all been switched off, nonetheless are in some way irradiating the atmosphere. Is that going to be said, therefore, now it is not safe? That's the essence of the point we're seeking to make. And we don't say, we say it isn't solved by just simply saying, well, it then comes in at the stage of
No, I'm not suggesting it's
practicability.
solved. Very far from suggesting it. My query is really directed to your assertion that this is the ordinary and natural meaning of the word safe.
I do adhere to that. I don't need to go that far, because if it's going to be read down in some particular way, the fact that this is a criminal statute does give warrant for such reading down. Can I just take you to the third, of the submissions? And I'm very conscious again that I must allow my learning friend Mr. Nolan his moment to engage your lordships on some of the critical facts. Paramore, nicely named, it's volume 5, tab 84, and this is Lord Justice Salmon, and the reason that I introduced that is that Lord Justice Salmon appeared to consider the concept of safety was a universal concept which was as applicable to common law as it would be to a statute. Here, someone fell. Again, it was a safe means of access case, but that matters not, because, again, it's the same section. And at 109, if your lordships be good enough to go to that, giving the first judgment at the invitation of Lord Justice Sellers, Lord Justice Salmon said this: 109, top of the left-hand column, the crucial question in this case appears to me to be whether the means of access provided was safe. No question arises at common law as to reasonable steps. It seems to me, because if the means of access was dangerous, it was quite easy for the defendants to take reasonable steps to make it safe. Similarly, under the statute, if it was dangerous, it was certainly reasonably practical to make it safe. For my part, I cannot think that the word safe can have a different meaning as according to whether you are considering its significance in relation to the statute or in relation to common law. Nor do I think, at least this is a merciful absolution, it is easy to define the meaning of the word safe. Many attempts have been made to do so, some of them difficult to reconcile with others. Whether, now this is his conclusion, whether a means of access is safe must depend upon whether the danger is reasonably foreseeable. And then at 109, again, having referred to authority, central paragraph of the page, 109, right-hand column, as I've already indicated, there are various dangers and difficulties in trying to define the word safe. I do not propose to do so. There is, of course, a risk of injury and accident inherent in every human operation. It is a question of assessing the risk in all the circumstances of the case, and the point comes where, according to the ordinary meaning of English words, the risk in the circumstances would be such that one would come to the conclusion that the means of access was unsafe. It must be a question of fact and degree in each case. So he, again, with respect, envisages that he is using language in its conventional way. I'm going, if I may, simply to give your lordships the fourth reference, because it is a somewhat tautly drawn paragraph. It's the judgment or speech of Lord Upjohn in the limo case, which I remind my lords was essentially the question of where the burden of proof was cast by concept of reasonable practicability. At page 124, I can simply tell your lordships against G. Lord Upjohn.
Where have we gone? 124?
This is Nimmo. This is, it's in volume 5, tab 29, but I'm not asking your lordships to go to it. I'll just, if I may, just tell you where you will find what. At 124G, Lord Upjohn refers to the infelicitous draftsmanship of this particular section. At 125G to 126A, he poses the question that I posed, my lord, in seeking to support my arguments. He asked the question, how can an exercise of taking reasonably practicable steps ever be carried out if the defect or danger of which complaint is made was not reasonably foreseeable? And then finally at page 126, he says these somewhat opaque words. The section requires the occupier to make it 100% safe, and then the key parenthesis, judged of course by a reasonable standard of care, if that is reasonably practical, is not to make it safe so far as reasonably practical, lower percentage. So again, although the language is very tightly drawn, it seems to us, in our respective submission, clear that Lord Upjohn was differentiating between the two stages and was regarding the reasonable foreseeability and so on at the stage of safe as distinct from only at the stage of reasonable practicability. And then finally, this is something I do think I need to show to my lords. If you'd be good enough to go to Austin Rover. I'm going to find the invoice. Austin Rover, volume 1, tab 46. Now this was a case. Vol 1, is it tab 46? 6, is it? Tab 6. Oh, volume 1, tab 7. Much obliged. This was in fact a case about the duties owed under the Health and Safety at Work Act to persons other than employees, in this instance independent contractors who came on the scene and were injured by some sump that exploded or overflowed with a consequent explosion. And Lord Gough gave a speech in which he did touch upon this issue about in that particular context of section 29.1, which he refers to at page 624, does reasonable foreseeability come into the equation at the stage of defining the words safe, or in the Health and Safety at Work Act, safe and without risk to health, or does it only come into play when one's concerned with reasonable practicability? And he accepts the second of the two. That's to say, his speech would be adverse to my submission. Now, the first point that I make is it is very interesting indeed that whereas the other members of the House on that occasion expressly agreed with Lord Jauncey, they made no comment at all upon the observations of Lord Gough. So the first point is they were clearly obiter in any event, since he was not concerned with section 29.1. The second point is that the statutory provision was differently phrased. He wasn't actually there concerned with duties to employees at all. And the third is that the other members of the House did not acquiesce in Lord Gough's construction. Can I just incidentally point out to you that at page 634, between letters F to H, this goes back to my argument about place and premises. The way in which Lord Jauncey analyses or applies the concept of premises is very much, on the face of it, restricted to physical environment and doesn't, as it were, appear on that application to embrace machinery, still less atmospheric conditions. That goes back to the first issue. But coming back to the one which we're presently praised, what Lord Gough says this at G. 624. To me, the words safe and without risk to health mean prima facie what they say, though no doubt they have to be related to the use for which the relevant premises are made available. Take the example of premises which, owing to an unknown and indeed unforeseeable defect, are in fact unsafe for such use. So this is, we're breast high with the Court of Appeal in this case, or a substance which unforeseeably possesses a characteristic which likewise renders it unsafe for such use. I do not for my part see how the unforeseeable nature of the defect or the characteristic can nevertheless mean the premises or substances are safe. The duty is to take such measures as it is reasonable for a person in the position of the defendant to ensure, so far as is reasonably practicable, that the relevant premises or substances is or are safe. It may be that if the danger in question is not foreseeable, the defendant will not be held to have been in breach of his duty. But if so, that will not be because in the examples I've given, the premises or substance are to be regarded as safe because the qualified nature of the duty may not give rise to any liability in the particular circumstances. And then he suggests that the cases dealing with the machinery shouldn't necessarily be read across to the provisions dealing with workplace, and he disputes the reasoning of the Court of Appeal in Allen and Avon. Now, we make 2 points. First of all, Lord Gough, just assume for present purposes, which we dispute, that Lord Gough is correct in saying the concept of safe is free from any connotation of foreseeability, then surely if it is to be intruded into the connotation of, or the phrase reasonably practicable, the answer ought to be that the defendant must succeed, not may succeed, because how could it ever be for the defence of reasonable practicability to be engaged if the defect is, putting it as high as Lord Gough is prepared to put it, both unknown and unforeseeability. So we say there's an inherent contradiction in Lord Gough's own analysis.
But isn't he construing the words such measures as it is reasonable for a person in the position of the defendant to take, rather than the words reasonably practicable?
No, Lord, with respect, if one looks at the last line on 624, one sees he is referring to so far as is reasonably practicable.
Yes, but the measures are to be such measures as it is reasonable for a person in the position of the defendant to take.
Yes. Well, that I accept. Indeed, I mean, our point with great respect is that reasonable practicability indeed concentrates on the measures that can be taken. And if one is to concentrate...
No, my point is that this statute is different.
Yes.
Because the words, as it is reasonable for a person in the position of the defendant to take, don't arise, do they, in our section, or indeed in the sections 2 and 3 of the 1974 Act.
Yes, but in a sense that, as it were, distances Lord Gough's analysis in any event from section 29.1. But what we do say is, I mean, Lord Gough's thinking, as always, is fruitful in this context. What reasonable practicability is concerned with is measures that you can take in respect of something that is unsafe. And we repeat the question that Lord Upjohn posed in the Nimmo case: how can you expect anyone to take any measures of any kind if you simply neither can nor should have foreseen the existence of the danger?
If the words "it may be that" were removed from the first sentence on paragraph 625, there would be no logical deficit in...
There wouldn't, no, that I accept. That I accept in any event, it actually directs one in the... It directs one in the correct, down the correct path that one was looking for under reasonable practicability. Measures to be taken, is it reasonably practicable? And one can only take measures in respectful submission in the anticipation of the legislature if one has some knowledge of, or capacity to have knowledge of, the danger. That's why what we call the retrospective analysis, that once and for all time, what we know now, even if you didn't know it then, cannot be a sensible approach.
But that's accommodated for, that's catered for by the circumstance that you cannot take what would be described as reasonably practicable measures against an unknown danger.
But that, with respect, I mean, it's a way of solving the problem, but in our respect, it doesn't actually align itself with the vocabulary. To say it's not reasonably practicable to take measures because you don't know about them, it's a very if I may put it that way, it's a very clumsy way of doing it.
But
Not
to my mind,
reasonably
I still
practical
think that
because
the
you
top
don't
of page
know.
65 is not about the expression, so far as is reasonably practicable. I think it's about the previous words at the bottom of page 624 at H, because he only turns on to so far as reasonably practical at D on page 625.
Yes. Well, I mean, it may be so. It doesn't actually do any violence.
Well, the reason why it's maybe significant is that one can see that you might get one answer if the duty is to take such measures as it is reasonably practical for a person in the position of the defendant to take.
Yes.
That is a separate duty from doing something which are such measures as are reasonably practical to cure the risk.
Yes.
Those are conceptually entirely different things.
Yes.
And it's only the latter which appears in our section,
Yes.
just as it's only the latter which appears in the sections 2 and 3 of the 1974 Act.
Yes, but well, my lords, I mean, be that as it may, and I'm prepared to accept that for the purposes of my argument, be as it may, what I say is, to say it's not reasonably practical to take measures which you can't, when you cannot be aware, are not and cannot and should not be aware of the defect or danger, in our respectful submission, is a very odd way of embracing that particular line of thinking. It fits much more easily if one assumes that within the concept of safety there is some notion of being able to foresee the existence of the danger. And against that background, you then ask yourself the question, since I know, or at any rate ought to have known of the danger, then what are the measures I can take? That's the way in which we would invite the court to analyse it.
Going back there, I mean, assuming that analysis may not be right, it would be a slightly odd situation if you could have a defence of reasonable practicability or not reasonably practical, which postulated you knew of a risk, but you couldn't do anything or wouldn't reasonably be. It wouldn't reasonably be practical to do anything about it, but have no defence where no one in the world one in the world would reasonably have identified there as being a risk at all.
Yes.
I mean, that would be an odd statutory scheme, I might think.
Yes, that's our submission.
So, I mean, you say it comes in under risk, but the alternative
That's a
is...
matter of policy, really.
Well, yes, but yes. A matter of policy one is not to attribute to the legislature something that is itself a duty that is wholly unable to be discharged or a result that is a nonsense. I mean, that is a general principle.
Are these points discussed by Lord, whoever it was, whose report we looked at?
Lord Robins?
Yeah.
Not as far as, I've only read that section dealing with noise, my lord. My learned friends, as it were, on guard now by my lord's question, can pick up the baton either later today or tomorrow. Can I just, before going to my last effectively head of submission, which I hope I can deal with very shortly, just before I leave safety, I just make two general points standing back. What we say is that where you have a situation, as is not uncommon, when there is a developing knowledge about the risks for every employee in a particular environment associated with a particular activity, the way in which that can be catered for is by the making of specific regulations, which actually is illustrated in this instance where noise was sought to be dealt with in the regulations that we've described. If, on the other hand, you're concerned with duties, not to the generality of your workforce, but to employees of a particular susceptibility to a particular hazard, when, and this of course is the condition precedent, the employer knew or ought to have known about it, that then, in our respectful submission, is catered for by the common law. Neither of those two propositions, if I'm correct, do anything other than support what we say about the meaning to be attributed to the word safe. My Lords, I've got two more matters of law, and I can really deal with them, I hope, very swiftly indeed. One is the question of what's meant by reasonable practicability, on which actually there is very little in law between the parties. We deal with this in our written case at 135 to 136. If we're right, of course, about what's meant by place of work, it being accepted that in this instance there is nothing that could be done to lower the noise level, either by some form of material attached to the walls or by some form of silence or baffling of the relevant machines, that the noise at the place of work was in that context as low as reasonably practicable. So that's, as it were, the defence is entirely made out. Whether, if provision of hearing protection, as it were, comes in there, that's something that will have to be addressed by my learned friend, Mr. Nolan. But you have my submission about the disconnect between that and an ordinary concept of place of work. But as far as law is concerned, what we say, I'll make, if I may, 5 propositions and then just identify what may be controversial. Proposition 1, what is the onus lies upon the employers. See the classic decision in Nimmo and the Court of Appeal at paragraphs 81 to 87. Secondly, it qualifies the duty under section 29(1), so whatever, as it were, the duty without that qualification may consist of. Reading them together, the duty is not, and it's, Lord Hope's vocabulary, an absent one. Thirdly, the word reasonably, in the context of reasonably practicable, must be given due weight. One has, for example, in section 63 of the same legislation, an obligation on an employer to take all practicable measures without the qualifying epithet. We say the legislature has chosen to differentiate between the two. The court should respect their choice. Fourthly, that what is reasonably practicable is obviously a question of the circumstances of any particular case. See for that proposition Lord Macmillan, the speech in Coltness Iron at tab 28 in volume 2 of the authorities at page 718. And fifthly and lastly, whenever the concept of reasonable practicability is put into balance, what is in issue, what the court has to do is to balance two factors, risk on the one hand against measures to address it on the other, and in respect of the first there are two features. One could have a greater risk but of a lesser injury, or one could have a more serious risk, though less likely to occur. Each of those have to be addressed in context of the measures to be provided by way of remedy. Now, where we, in a sense, depart from the Court of Appeal judgment, which is dealt with effectively at paragraphs 83 and 84, is this. The Court of Appeal, in our respectful submission, have intruded into the concept of the measures to be taken, that they have to be, the steps to be taken have to be disproportionate. There has to be an establishment of other than a simple disproportion between risk and cost. They say there has to be a significant disproportion, and we respectfully submit that that is not vouched for by any of the authorities that we've cited in the relevant paragraphs of our printed case, and in particular, just for your lordship's note, in the Austin Rover case that we were examining for different purposes a few moments ago, volume 1, tab 7, Lord Gough deals with the majority of the authorities between page 625 at letter D and 627, the entirety of the page, I think going over it maybe to 628B, and at no stage describing those authorities as he does as authoritative, and he uses that epithet at 625D. Nowhere does he say that one needs to establish, as it were, a gross disproportion before the defence is in fact engaged. And what we do have, the other point we would wish to make from the passages we've cited in the printed case, is that both, two more points, both Lord Justice Asquith in Edwards, that's Volume 3, tab 42, page 712, and Lord Oaksey in Marshall and Gotham, which is at Volume 5, tab 72, at page 370, both make it clear that one has to look into, as it were, the mind of the employer at the stage or before the accident occurs, and not after, with the benefit of hindsight. And that, in our respectful submission, again shows that one has to look effectively at what were the standards that one assumed were to be required. And the third point, the last point, the first point, differentiating between disproportionate and grossly disproportionate. Second point is look at it antecedent before the accident occurs and not with the benefit of hindsight. Third point is that insofar as a more stringent test appears from the authorities to be imposed on employers, that can be explained either on the basis that statements are being made as to what would satisfy the statutory test, and not statements as to what would not satisfy it, or the cases just illuminate findings of fact in making their statement of how they approach the matter. And we say then, my learned friend, Mr. Nolan, will address you on the factual areas in relation to reasonable practicability. The last point I need to deal with is the common law, and I can deal with that even more shortly. We've dealt with that effectively.
And can you just help me on that last point? You submit that you should look into the mind of the employer before the accident.
Yes, they look at it antecedent. Was it reasonably practical, given what you knew
when
before?
exactly, in Mrs. Baker's case, should one look at the mind of the employer? 18 years before?
Well, you see, of course, that takes one back to the difficulty. How on earth could my clients have... First of all, they didn't know she was reasonably susceptible. But even if they did know that she had a particular susceptibility, they had not the slightest idea as to how long she was going to be employed for. And that's why we respectfully submit it's really impossible to impose the duty under Section 60, to impose upon us the duty under Section 29(1 to say we've been in breach of it. It just simply isn't catering for that kind of situation. It's catering for the structure being unsafe. Something happens, it goes wrong at the time.
I mean, the point, the difficulty about that is that it could be said of other conditions that would be deleterious to health, that you wouldn't know that they'd stay there and be exposed to bad ventilation or poor lighting and so on. If they were there for a week, it wouldn't matter. And yet, I'm sure that they could attract liability, couldn't they?
Well, there are specific provisions, of course, dealing with those particular
Yes.
matters, and one would have to look at those sections to see how it works. I mean, what happens, of course, is one has, as it were, absolute standards or threshold standards. You all know what you're working to, which doesn't require, as it were, prophecy. You're making an assumption that if X isn't done, then Y, the injury, will or may occur to a particular group.
It comes back to your basic point. Was this a disproportionate exposure?
That's another thing. It's a
Risk.
You know, exactly. We have to. Yes. Was it grossly? Yes, they would say the Court of Appeal, but just excluding that particular pejorative adjective. I think the 3 points that arise under common law in law are just 3 points we've dealt with. I think effectively. I hope comprehensively. What is the test to be applied? It's Swanwick, Mr. Justice Swanwick in Stokes and Geske in Nettlefeld. We would add to that, and we would ask you to look at Mr. Justice Mustill in Thompson, the starting point of the jurisprudence on injury by noise at 7 volume 10 at 415 to 416, because he builds on Mr. Justice Swanwick and saying, effectively, it's the well-known phrase, employers are not expected to plough a lone furrow. That's what we say we would be being asked to do, all of us, if we were being asked to depart from codes of practice. The second, the relevance of codes of practice, we deal in the printed case at 162. What is interesting is that Mr. Hendy refers to the Green case. The Green case was actually a case where, even though there was a departure from the code of practice, nonetheless, negligence was not established. It certainly can't be used for the contrary proposition that codes of practice, especially those generated in the way in which this was and the time this was, are not themselves relevant to define the ambit of the duty. And the third legal issue is the way in which a court of appeal should approach a decision of a judge at first instance who has heard and read all the evidence. And we refer to judgments of my Lord Justice Clerk, as he then was in Assi Curazione, and various observations of my Lord Mance in the House of Lords, being able to approve a view expressed previously in a membership of the Court of Appeal. And what we say is really two matters. First of all, although a Court of Appeal is entitled to determine what findings of fact or inferences drawn from facts are wrong, they must give full weight to the advantages enjoyed by the judge at first instance who's heard oral evidence. And secondly, where the decision of a trial judge involves a judgment on unchallenged primary findings and inferences, the Court of Appeal, and again we quote from my Lord Mance, then in the Court of Appeal, ought not to interfere unless it satisfied the judge's conclusion lay outside the bounds within which reasonable disagreement is possible. And we note, just for your Lordship's note, that in the Harris case, to which the Court of Appeal were apparently oblivious, Lord Justice Neuberger, as he then was, at paragraph 57 of his judgment, properly reminded himself, which this court did not, of the limits of its powers in an appellate role. And the failure to follow those precepts was, in our respectful submission, the last, if not the least, of the errors of the Court of Appeal in dealing with this matter. As my learned friend, Mr. Nolan, subject to any further questions my lords have to put, will now address.
But you are yourself seeking to set aside some of the findings, aren't you, in relation to the special knowledge point?
No, on the contrary, my lord, it's the Court of Appeal who, on the basis of a solitary piece of evidence that was clearly in the mind of the learned judge and rejected, said there was not. Yeah, no, that's entirely consistent with. I'm very conscious of the fact that in relation to other matters, I do have the advantage of anything I have missed will be picked up.
Could I just ask you one final question?
Yes, indeed.
Should we approach the meaning of reasonably practicable in the same way as it's approached in section 40 of the 1974 Act?
Can I just look at, this is volume 10, tab 31, is it? No, you've got to help me make it work. Sorry, can you even give me the act? Yeah, that's health and safety at work. Was your Lordship asking about the 1974 Act or the 1961 Act?
I was asking about the 1974 Act.
We don't have.
Maybe we don't have 74. Oh, well, no, we'll come back.
But I'd be very, may I just say, in principle, I would not say that the definition in an act, even covering cognate territory, could be simply read across. But I'll come back to that, and those of my learned friends have the opportunity of considering it. So, my Lord, unless there are any further questions, those are my submissions, and Mr. Nolan will now follow.
Thank you very much indeed. Mr. Nolan? Yes.
May it please your lordships, my lords, I set myself the task of completing the entirety of what I wish to submit to your lordships by 4 o'clock. My lords, as my learned friend Mr. Belloff has indicated, I do intend to add a little factual detail, conscious that your lordships have all had and taken the opportunity to consider the printed cases. So, my lord, notwithstanding that, I do want to, as it were, presage a submission that I think your lordships are likely to hear tomorrow, in case it assists. And if your lordships will permit me, I'll merely state it and allow it to be developed by others. But my Lord Clerk raised the question of the separation, as it were, of the consideration of the question of reasonable practicability from safe. Your lordships, I'm sure, will be acutely aware that the section 29 requires that the place shall, so far as reasonably practicable, be made and kept safe. It's not a provision that the place be kept safe and then a subsection allowing for defence of reasonable practicability. And, my lord, the idea that the reasonable practicability qualification is, as it were, enmeshed in the issue of safe was precisely the view that both Lords Reid and Wilberforce took in the minority in Nimmo. They adopted the phrase in the court below, that being a Scottish case, the Inner House, that they were, if I paraphrase, of a piece.
So what does the claimant have to prove?
My lord, the claimant has to prove that the place was not safe so far as reasonably practicable. And, my lord, if I can indicate...
And how does that impact upon the onus of...
well, my lord,
on the burden of proof?
My lord, as I was about to venture, in the whole point of, as your lordships will see when your lordships consider Nimmo, the whole point of Nimmo was that it was to test the question of onus. And your lordships will see that it was actually set up, pleaded and set up as a test case. And, my lord, one could not, with the greatest of deference and respect, dispute that their lordships got that right. And as your lordship has observed, in section 40 of the Health and Safety at Work Act, expressly the onus of reasonable practicability is on the defendant. But, my lord, the House of Lords in Nimmo having decided onus, what happened then is that was applied, one might say, and this submission I suspect will be developed, misapplied in the likes of Lana and Mains, as it were, to create an impression that safe is absolute. My lords, none of the appellants have the slightest difficulty with the concept of safe being wholly objective. My Lord Kerr's point about, as it were, an element of subjectivity. Nobody contends for that. But, my lord, absolute is not what is required. And, my lord, the submission that your lordships are likely to hear is along these lines. In Nimmo, both Lords Reid and Wilberforce, in seeing the reasonable practicability qualification within safe, and saying they were, as it were, of a piece, were joined, as it happens, by Lord Upjohn, because the dictum of Lord Upjohn at 126, which my learned friend Mr. Belloff referred to, saying, according to reasonable standards, as it were, he then aligns himself with Lords Reid and Wilberforce. Lord, what has happened is that distinction which my Lord Clerk has identified has, as it were, been used, some might say misused, to render safe, the definition of safe, as though it were an absolute. And what has happened is...
So what direction do you have to give the jury in a prosecution under Section 2?
My Lord,
I mean, what is it that the prosecution's got to prove?
Well,
and what
Lord,
is it that the defendant's got to prove?
Well, my Lord, if I put it this way, if one were to follow the approach of Lady Justice Smith in this case, one would send the jury out to consider safe. Was there any risk? Doesn't matter whether it was foreseeable or not. And then once they delivered their verdict on that, then they'd be asked to return a verdict on reasonable practicability. The appellants seek no more or no less than a reading of the statute as it reads, which is, shall so far as...
So what's the answer to my question? What would you have to tell, if you were the trial judge, what would you have to tell the jury that the prosecution had to prove? And what would you tell the jury that the defence had to establish?
Lord, the prosecution have to prove that the place of work was unsafe.
Yeah.
And, my Lord, what I'm saying is, and then, of course, the defence...
And that's the only thing they've got to prove?
Yes. But,
and so if there's no defence, that would be the end of it?
Lord, yes. What I'm saying is with respect, Lord, impermissible.
is to say that because one approaches the onus of proof in that way, that makes safe an absolute. Because, my Lord, it's a trite point to say that one is
I
never...
wasn't suggesting it did say that. But it doesn't import the words in the statute, though, does it? You don't have to say because the actual statute uses the words, doesn't it? In sections 2 and 3 also uses the words.
Are we talking about the 1974 Act?
Yes, and I was talking about the 1974 Act. Well, I think the position is the same under the under our Act.
Well, my point is that there has been, if NIMO, as a...
Yes, my point is, anyway, if you look at section 3, it says it shall be the duty of every employer to conduct his undertaking in such a way as to ensure, so far as is reasonably practicable, that persons not his employee who may be affected thereby are not exposed to risk to their health or safety. But because that has to be read with section 40, all you have to say to the jury is, well, now, members of the jury, all you have to be sure about is the section without the reasonably practicable point, because that is catered for by section 40. Isn't it?
Yes.
Isn't that right?
Lord,
you don't have to direct the jury that the prosecution has to prove anything about reasonable practicability.
My Lord, my point is, when the jury sends a question which says, what do we mean by safe? Does safe mean the elimination of all risk? What is the answer to that question? And my Lord, the answer to that question is safe according to reasonable standards, which is what Lord Upjohn said in NIMO. And my Lord, the force in my point, in my respectful submission, comes from the standards...
So you have to tell the jury it's safe, what? In accordance with reasonable standards?
Yes, Lord. Well, I would adopt the words of Lord Upjohn in NIMO.
Right.
The difficulty I having at the moment is there in the papers somewhere a reference to section 40, and it seems to me that the difference in language between section 3 and section 29 may make this a slightly difficult exercise.
Well, that may be so. I mean,
what does section 40 say?
Section 40 says, in any proceedings for an offence under any of the relevant statutory provisions, consisting of a failure to comply with a duty or requirement to do something, so far as is reasonably practicable, it shall be the accused to prove that it was not reasonably practicable to do more than was in fact done to satisfy the duty or requirement, or that there was no better practicable means that was in fact used to satisfy the duty or requirement. Well, that's what section 40 of the Act says.
Well, the appellants have no quarrel, if I may put it that way, my Lord, with the unshackling, as it were, of safe from reasonably practicable, as it were, contrary to the gut instinct of Lords Wilberforce and Reid. But if one allows them to be unshackled, my Lord, what I submit is that it would then be wrong under that guise to treat safe as absolute and unqualified. And my Lord, that is the thrust of the decisions in both Austin Rover and the factories inspector, and Shargo, as I pronounced, or Shargot.
Yeah,
and my Lord, it's the qualified definition of safe, even if one has unshackled them properly in accordance.
You say safe should be construed as if it said in accordance with reasonable standards.
Lord, yes. Lord, objective, no subjective defence, but not absolute. In a world where absolute safety, if I make the trite point, can't be guaranteed. Lord, a forklift truck driving around a factory floor is never going to be absolutely safe. But is it a prima facie breach of section 29? My Lord, there might be an argument against it. My Lord, having taken up some of my allotted time...
I beg your pardon, that's my fault.
Well, my Lord, that'll teach me. My Lord, I'm going to, if I may, put a little factual background, as I say. I'm going to highlight some aspects only of the history, conscious that it's before your Lordships, the history of the developing, not knowledge, because the knowledge has been fairly static, but the developing approach, as it were, to risk from noise in industry. And also one or two aspects of Mrs. Baker's claim that your Lordships, I respectfully submit, should be aware of, considering how this case should be decided. My Lord, those matters will inform consideration of a number of issues. I'll simply identify them. Safe, if section 29 applies, reasonable practicability, and also the question of common law duties. My Lord, I'm not at this stage going to summarise the first appellant's case at common law. My Lord, that's in the written case, and to a certain extent has already been re-amplified or re-clarified in the written submissions, the written outline that my learned friend Mr. Beloff handed in. My Lords, can I take your Lordship to some of the documentation, because aspects of it, and I emphasise merely aspects of it, do repay in consideration. My Lords, I'm not going to go back as far as the 1960s, as your Lordships, I think, are now aware. the world looked differently then. In the 1960s, the cases that one reads and the approach that one sees reflected the very heavy noise in industry, heavy industry noise. And it's only in later years that light industry has come to be considered as a potential source of harm. My Lord, can I begin with the 1972 Code of Practice, which is a seminal document in this case? My Lords, that's in Core Bundle Volume 3 at tab 13. My Lords, I would take your Lordships, if I may, first. Pages, core bundle pages, if I go from the numbering at the very bottom of the page, 165 and 166, one sees the foreword and the make-up of the subcommittee which was brought together to bring out, to publish this Code of Practice. My Lord, all I refer to from the foreword, your Lordships will read it for yourselves, is in the last part where there is a reference to it should be considered as a blueprint for action, about 10 lines from the bottom of the foreword. My Lords, I'm not going to recite the membership of the Industrial Health Advisory Committee, Subcommittee on Noise. Your Lordships can see it for yourselves. My Lords, a complement of all aspects of industry, academic, union and employer. My Lords, the gist, the essence of what this code is about is on pages 1069 and 1070 of our bundle, going from the numbering at the bottom of the page. Lord, it is right to say at the outset that the code did not purport to set a standard that would eliminate risk. And Lord, that is clear from 112 at the top left-hand part of the first of the pages I identified. If I may read that short subparagraph, the code sets out recommended limits to noise exposure. It should be noted that on account of the large inherent variations of susceptibility between individuals, these limitations are not in themselves guaranteed to remove all risk of noise hearing loss. Lord, I'll be taken to a passage if I've overlooked it, but that in the Court of Appeal's judgment in this case became transformed into likely risk, and I take that from Lady Justice Smith's paragraph 6. Lord, it was not said to be a likely risk. That was how it was put by the Code of Practice. Can't be guaranteed to remove all risk. My Lords, your Lordships will see at section 4, limits, and precisely particularly at paragraph 4.3 on the second of the two pages, continuous exposure. If exposure is continued for 8 hours in any one day and is to a reasonably steady sound, the sound level should not exceed 90 dBA. My Lords, that is the fons et origo of the 90 dBA limit. My Lords, if one looks at paragraph 512, one gets that in some context, because paragraph 5.1 deals with surveys, and 5.12 advises this: surveys are advisable when it is necessary to shout in order to be audible to a person about 1 metre distant. Well, my Lord, that bears a stark contrast to the circumstances of this case, as I will outline in due course. My Lords, I could take your Lordships painstakingly through the very numerous references within this Code of Practice to the limit. It is stated over and over again, but my Lords, that's not necessary. My Lords, I need only highlight, before leaving this document, paragraph Appendix 4, which is core page 1084, which dealt with ear protectors. And my Lords, as I'll outline in due course, this case is solely about ear protectors as measures to combat the effects of noise. In paragraph 31 of that Appendix 4, my Lords, bundle 1087, if I may, ear protectors should normally be specified so that the sound level at the user's ear is always effectively reduced to 90 dBA or less. My Lords, that, as I have said, was the clearest of statements. My Lords, I don't need to take your Lordships to the next document in the bundle, which was superseded very quickly. And my Lords, I take your Lordships now to tab 15, if I may. My Lords, this is the British Standard for 1976. Before identifying one or two aspects of this document, I should say, it's unfortunate that the documents are not in strict chronological order. In between the last document that I showed you, Lordships, and this British Standard in 1975 was a document framing noise legislation, to which my learned friend Mr. Belloff referred earlier today. And Lord, that was the one that said the 90 dBA standard had achieved international recognition and so on. Lord, I alight at the 1976 British Standard because, as your Lordships will recall, it was this document which was held by the Court of Appeal effectively to render all of the appellants in breach of their statutory duty. Because Lady Justice Janet Smith held that because this method of test for estimating the risk of hearing handicap in due course, published in July 1976, in due course allowed some estimation to be made of how big a risk there was of moderate hearing loss. Therefore, she held that it was no longer permissible to, as it were, comply with the Code of Practice. My Lord, it is the appellant's submission that is not a proper conclusion to reach if one looks particularly in the foreword to this British Standard, where it expressly identifies the Code of Practice as the standard. My Lords, I'm looking at page 1109 of our bundle and the last paragraph of the foreword. If I may read that short paragraph, my Lords. Determination of a maximum tolerable noise exposure is outside the scope of this standard. It involves consideration of risk in relation to other factors. For occupational noise exposure, such a limit is specified in the Department of Employment 1972 Code of Practice for reducing exposure of employed persons to noise. My Lords, the point I make about this standard is self-evidently made in the passage that I have read, and I don't labour it. My Lords, I respectfully submit that here the Court of Appeal fell into error in holding effectively that a standard which was a measurement tool undermined a practice universally applied of international recognition, where the said standard expressly referred to the Code of Practice as the standard, was in the submission of all of the appellants an inappropriate application of that document. My Lords, later documents I can deal with relatively briefly. My Lords, we need to consider at tab 19, we need to move to core bundle volume 4 and tab 19. Because, my Lords, we move from the 1970s to the 1980s. And at tab 19, your Lordships will find a consultative document for the protection of hearing at work published by the Health and Safety Commission. And Lords, I refer to two things about this document. It's a long document, and your Lordships will be relieved to hear that I don't intend to dwell on it at any length. But the purpose of this document was, if I can use the phrase, to regularise the position under the Code of Practice. And the essence of this document is to say that the Code of Practice is a voluntary guide being followed, but it ought to be backed by legislation. And, my Lords, they're not my words, they are in the introduction at Core Bundle 1322. But, my Lord, the regulations, the draft regulations of 1981, are at 1331, if I may take the Lords there. That's internal page 10 of the document. And there are the proposed protection of hearing regulations. My Lords will be aware that eventually when the regulations did come, they were called the Noise at Work regulations. But that was the working title at the time of this document. an interesting law. It's a small point, but the limit, the hazard is deemed to be in excess of 90. So, my lords, so much for 1981. My lords, what is interesting about this document is that it refers to the woodworking machine regulations, but does not suggest any view held, at least on the part of the HSC, that the Factories Act applies. My lords, I don't give that point any more weight than it deserves.
Where is the reference to the woodworking regulations?
Well, in the, it's implicit in the introduction. To date, however, was the paragraph I read at 1322. Perhaps I should have read the paragraph. I apologise.
Yes, I see. That's it. Yes, thank you.
Yeah. There were only two, woodwork machines and tractor cabs. Well, I don't think tractor cabs assist other than to say that the 90 dBA limit was there too. But your lordships will be aware that woodworking machines were only in factory premises. Woodworking machines covered were only in factory premises. And my lords, I pose, as has been posed in the written cases, what was the need for those regulations if section 29 applied. My lords, I move to the next document in the history, which is in 1982, which is the draft directive. My lords, that's at tab 20. Thank you. My lords, the importance of this document, the importance it was given cannot be overstated. Lords, it was this document that persuaded the existence of this document and the existence of one witness's awareness of this document, which persuaded Lady Justice Janet Smith that the appellant, whom my learned friends and I represent, had specialist knowledge. Lords, I would refer to this document in brief, if I may. It was a draft introduced, as it says on its face, and I'm at page 1374 of our bundle, on the 18th of October 1982. Lords, it was withdrawn without ever becoming law anywhere in June 1984. Lord, it's stipulated.
Was it preceded, did anyone ascertain, by any green paper or anything of that sort?
Lord, no, my lord, what happened, so far as the UK was concerned, I just took my lords to the 1981 consultative document. And what happened was when the EC brought out this directive, the HSC dropped its consultative document and began dealing with this directive. Lord, it is common ground that there were submissions from both sides of the industrial fence, if I may say, as to this draft directive, some saying the protection was too strong, some saying it was too weak. But the debate was such that it was never adopted. It was eventually replaced in due course. My lords, I'm coming to that. Lords, it's important that your lordships are aware, first of all, that this was the proposal was a limit of 85, and that's an Article 4.2. And lords, I'm paraphrasing, but your lordships have, I'm sure, have the point. But your lordships see in Articles 5, 6, 7, 9, 10 and 11, which I don't read, a panoply of measures. I refer to that panoply because one sees at least twice in the respondent's written case the phrase cheap, quick and easy in reference to hearing protection, as though one merely needed to leave a box of earplugs out and the problem was solved. And the Lords will see that so far as the EC was concerned, the problem of noise at work, as perceived, whatever its extent, required a panoply of measures, none of which it was expected would be implemented immediately. And my lords, there's particular force in that point, because may I take you, lords, to lordships to Article 4.2, which I had alighted on briefly. And my lords, this is on core bundle page 1375. And I identified the exposure limit as 85, but there's a qualification. May I read that qualification? It said this: where it is not reasonably feasible to comply with this limit, my lords, that's the 85, from the date on which the measures provided for in this directive are to take effect, the limit value may be increased to 90 for a transitional period of a maximum of 5 years from the aforesaid date. Before granting such derogation, the responsible authority of the member state shall take into account the preventive measures incorporated into the design and construction of the installation in question. My lords, the date your lordships will take from Article 16 was 31st of December 1984. That's on Core Bundle 1377. So, my lord, what this draft directive said was not that a limit of 85 was in place, not the limit of 85 was coming, it was a draft, not even that if it did come, it would come soon, because potentially the limit of 85 would not arrive until January 1990, which of course, as your lordships are aware, is what did happen eventually, albeit with 85 being a discretionary hearing protection level rather than mandatory. So, my lords, your lordships anticipate, no doubt, the submission I make is that this document, a draft directive with the qualifications that I've outlined, may not, and the appellants submit, was not a good reason to fix the appellants whom I represent with specific knowledge.
Did it ever get in front of the Council of Ministers? Did it ever get in front of the Council of Ministers?
There your lordship has the advantage of me.
I mean, this is just a proposal from the Commission. It doesn't have, without seeing the material behind it, one doesn't know who promoted it to them. There wasn't an impact assessment or anything.
Well, my lord, those who were in this case before I was, at its earlier stages may assist, my lord, but I can tell your lordship that it was June 1984 that it was withdrawn. I don't know if that would assist to any extent.
Well, it might have got in front of the Council of Ministers. It might have been that it was so controversial it never really progressed anywhere, but
well,
we don't know.
It's common ground that certainly in the UK it provoked controversy because there was a debate, and your lordships can imagine the tension without me needing to specify it.
So this was replaced by a later directive?
Lord, yes, Lord, I mustn't mislead. It fell by the wayside or was withdrawn in 84. Yeah. The next directive didn't appear till 86, and Lords, I'm coming to that now. Lords, that is at 22.
And this was promulgated?
Lords, yes. Lords, this directive eventually became, or was adopted in the 1989 regulations. My lords, Lord Leonard Friend, Mr. Belloff assists me in identifying that from the front of the draft directive of 82, the last one we looked at, it was submitted to the Council. Whether that takes my inadequate answer to my Lord Mance any further, I don't know. My Lord, the 1986 directive we have arrived at. My Lords, this document is important not just for what it eventually became, but for this. This was the first time that the concept of advisory hearing protection gained currency. Everything before then had been on the basis of protection or not. And as your lordships have already been referred to the case of Bucks and Slough Metals, a provision of protection traditionally means enforcement of wearing. What the 86 directive said, introduced, which was new, was two levels, a first action level and a second action level. Well, they weren't described as such, that was how they became described in the subsequent regulations. But, my lords, I need only refer to Article 6 in this regard, and the distinction between Articles 6.1 and 6.2. At 6.1, where, and my lords, I'm at bundle page 1407, exceeding 90 dBA, so my lords, that is, well, it is what it says, it's not at 90 dBA, but in excess of 90 dBA, must have hearing protection. Exceeding 85 must be made available. And Lords, that's an important distinction, because if one talks about what steps the reasonable employer would be required to take, or alternatively, what was reasonably practicable, or in the further alternative, what is properly to be considered safe, it is clear that even in this directive, in the 85 to 90 bracket, there was not, and I emphasise this, my lords, there was not a move to remove risk completely. It was merely advisory. And my lords, that begins to show into an even starker light the step taken by the Court of Appeal, in this case, in retrospective application of standards. My Lords, as I've indicated, the 1986 directive eventually formed the core, if I may use that phrase, of the 1989 regulations, but not before the process of proper consultation had gone through. And, my Lords, that's the next document that I take your Lordships to, and that's at tab 23.
The directive was to be brought into effect by 1st of January 1990. When those
Lords, I'm sorry, yes, I should have identified. That's in Article 13.
Yeah.
And, Lords, it was, as your Lordships are about to learn, was complied with in due course. But, my Lords, I was coming to the step in between, and this is the draft proposals. Now, this document, a consultative document at tab 23, Lords, this has a potential importance because in his core finding, if I may use that phrase, on the question of common law duty, the judge at first instance, Judge Ingalls, referred to the 1987 consultative document. Lords, I am going to submit in due course that his mere reference to this document was given a weight by the Court of Appeal that it really did not merit in that paragraph. But I only say that by way of, in parenthesis at this stage, because at the moment my task is simply to outline what the document said, and I'll develop the submission I've indicated a little later. My Lords, this document is what it says. In a sense, it is a consultative document, and your Lordship see from page 1412 of our bundle that it is published from the print date in November 1987, that's at the foot of the page, and seeks answers by June 1988. Your Lordships, my Lords will see at paragraph 3 in the preamble, that's at core page 1414, this at paragraph 3, industry will need time to familiarise itself with the final regulations, and they should therefore be made some months before the deadline of 1st January 1990. We hope to submit our final proposals to the Secretary of State for Employment in good time to enable this to be achieved. And accordingly, comments on the draft proposal should be sent no later than 30th June 88, as indicated on the front cover. My Lords, even there at 1987, an acknowledgement that instant change was simply unfeasible. And what is contemplated by the authors of this document is at a yet further stage, that is to say, after consultation, but pre-enforcement, pre-drafting of regulations, or pre-enactment of regulations, there needs to be time for industry to familiarise itself. Lords, as to the core of it, Lord, if I take my Lords to paragraphs 10 to 12, that is between pages, internal pages 4 and 5, certainly the view of the HSC at this stage was that the Code of Practice continued to hold the key. And my Lords, I have to read it all in fairness, and I've got to read, if I may, 10, 11 and 12. They read as follows. The 1974 Act already requires employers and others to do all that's reasonably practicable to protect the health and safety of persons at work, and this includes protection of hearing. Guidance generally used is the Code of Practice, reducing, etc., first published in 1972, now published by HSE. There are also a few explicit legal requirements, and there's reference there, my Lords, to the tractor cab regulations and the woodworking machine regulations and regulations containing merchant shipping. And over the page, this, in paragraph 12, considerable progress has been made under the 1974 Act, general duties, but there can be doubt about the applicability of the 1972 Code's detailed provisions in the Code itself, which was not produced for its present use, is out of date. Our 1981 consultative document was designed to remedy this and provide a uniform legal framework applying to all workplaces. The comments on this document generally favoured new legislation, though there were different views on what this should require. My Lords, of course there is an acknowledgement there that the 1972 Code of Practice has probably had its day, but your Lordships will recall that the 1981 consultative document was also for the same limit of 90 dBA. What is not said here, of course, is that the Factories Act, section 29, applies in any event. My Lords, it's worth identifying one particular factor of the potential problem. If one goes back a page to the table that's on internal page 4, because at paragraph 9, the Health and Safety Commission in 1987 was trying to identify the cohort of people with noise exposure at 85 to 90. My Lords will all be able to read for yourselves the figures in Table 2, 85 to 90, 710,000 people. My Lords, that is the potential scale of the problem. When Malone and Friends solicitors achieved their success in the Court of Appeal, the website quickly said, opening the doors to tens of thousands of claims. My Lords, I don't say that the appellant should succeed solely on the ground that there are a lot of claims, but your Lordship see the scale of the problem and the scale of the effect of the retrospective legislation, which we respectfully submit the Court of Appeal was tempted to indulge in. My Lords, in pure chronological terms, I've missed out one document, but it does repay a brief visit. My Lords, can I ask your Lordships to turn up white volume or sort of lever arch volume numbered 5, which is the continuation of the appendix.
So, can you give me that reference again?
White volume, lever arch volume numbered 5.
Yep.
Lords, within that volume, one sees a tab 42, a document that I'd like the Lords to consider very briefly. If my Lords have tab 42, your Lordships will see that it's a document prepared by the Joint Standing Committee for the Cotton and Allied Textiles Industry, Recommendations for Health and Safety at Work. My Lord's, internal page 1 on the next page of your Lordship's bundle identifies that the document has been prepared by the Health and Safety Executive and is up to date July 1985. My Lords, that is comfortably beyond the date at which the Court of Appeal has held the appellants in this trade to be in breach of their duty. Lords, it's worth reflecting for a moment, if I may ask your Lordships to do so, that when one looks at the contents of this document, which are on the next page, recommendations for securing safety in, firstly, spinning mills, then in the weaving industry, they are both directed at safety. They run to 30 pages. And the Lords, one sees on the next page, safety recommendations for the finishing industry, and then health recommendations. And Lords, I don't pretend for a moment that the Health and Safety Executive's classification is going to be for a moment binding on your Lordship, but it is interesting that they see noise as a health issue and not as a safety issue. And my Lords, that is a submission that I expect may be developed by from Mr. Lim on behalf of the third appellant with reference to the Factories Act. And my Lords, the other factor, of course, is that noise is dealt with very briefly at page 37 in a document that deals comprehensively with others, and one might say more serious risks. Lords, can I take your Lordships to that reference, and that's internal page 37, as the contents page has just indicated. And Lords, one sees the point is dealt with fairly briefly in the course of this page. At paragraph 9, there shall be compliance with the recommendations contained in the Code of Practice. The following recommendation shall be in addition to the previous recommendation, and then a limit. And my Lords, your Lordship see a specified limit. People shall not be continuously exposed throughout their working day to sound levels in excess of 90 dBA. And in the next paragraph, in the reference to ear protection, there is a reference to the limit. And under noise control, I'm down at paragraph 12 now, in the first substantive paragraph, reference again to the limit. And my Lords, that has to be 90. So, my Lords, in the summer of 1985, authoritative Lordships might agree direction from the Health and Safety Executive that 90 dBA was the standard to be achieved.
Was that referred to in the Court of Appeal's judgment, or
Lord,
the judges?
My Lord, so far as I'm aware, certainly not by the Court of Appeal. My Lords, so much for the attitude. And Lords, this is not a case, when I say the attitude, of course I mean the attitude of officialdom to the question of noise exposure at 85 to 90. My Lords, this wasn't a developing picture until very shortly before the 1989 regulations came into force in 1990. Because as I've said, it was only the draft directive of 1986 that began effectively to address the question of 85 dBA plus. My Lords, can I very briefly, in the space of a few minutes, identify some factual aspects in Mrs. Baker's case, because it is emblematic, I would respectfully submit, of the sort of situation that the courts are going to be dealing with if this judgment of the Court of Appeal is allowed to stand. My Lords, the noise exposure is dealt with in the judgment at paragraph 182. My Lords, can I take your Lordships to Core Bundle 2, page 575.
Sorry, whose judgment is this?
Judge Ingles. Tab 6, my Lord, and bundle page 575.
Paragraph?
182, my Lord. My Lord, I'm not proposing to read the paragraph. Your Lordship see that from that paragraph, the bracket, as assessed by the engineers, was 84.86.5. I get that from the fifth line down at the top of page 576 in the bundle. And my Lord, the finding of the judge was 85, perhaps up to a maximum of 86. Lords, evidence of perception of noise is important. Can I take the court to paragraph 135 and some of the evidence that was heard before the judge about noise? At paragraph 135, Lords, I should have assisted, it's page 552 of the bundle. And there's reference at paragraph 135 of Judge Ingles' judgment to Luckman and Coles. They tried to relate, these are medical experts, tried to relate noise levels to workers' perception of how difficult it was to communicate in a place of work in the 1980s, validated by obtaining evidence from workers at Rolls-Royce in Derby and players in Nottingham. The result of the survey was that at a distance of 4 feet, normal voice could be used at less than 80, a raised voice was necessary at 87, very loud voice necessary at 93, and so on. Well, Lords, your Lordships will already have tumbled to what I'm referring to. This exposure of Mrs. Baker was less than that you would need for a raised voice at 4 feet. Compare and contrast the code of practice, which was a shout at that distance.
Well, I mean, are these absolute cut-off points? I mean, a normal voice could be used at 80 plus, then a raised voice was necessary at 87. Does that mean that between 80, say, let us say 84 and 87, a raised voice wasn't necessary?
My Lord, no, of course not. No. But my Lord will be aware from the material seen that a 3 decibel increase is a doubling of the sound energy.
Right.
It's a logarithmic scale.
Right. So I'm not so sure that it can be said that a raised voice would not be necessary, given the levels that Mrs. Baker was exposed to. Can it?
Well, my Lord, I ought to be fair, and I was certainly coming to this, that the judge at first instance felt in the end that he was best guided in terms of making his assessment of what the noise exposure was, best guided by the engineers who will have taken sound measurements. of the lay witness evidence he heard, he felt that perhaps the most realistic analysis was where you would need to raise your voice a little if entering a public house. So, my Lord, I'm not contending that it was in the 80 bracket for normal speech, but I am drawing the distinction between raising voice and having to shout. My Lord, Mrs. Baker's perceived hearing loss. Can I take your Lordships to page 180, paragraph 182 of the judgment? And my Lords, that's core bundle 575. Lords, Mrs. Baker had left the employment of the first appellants in 2001, and the judge, in assessing what was known about her complaint of hearing loss, said this: she'd been to the doctor, Lords, I'm reading paragraph 183, for her ears at various times, some dizziness, ringing in the ears, wax and tinnitus in 2000, hearing loss not mentioned. She did not in 2000 or 2001 think that there was a hearing loss, anything wrong with her hearing. Lords, can I skip, I hope not unfairly, to the next paragraph, about 10 lines from the bottom, in evidence Mrs. Baker. In evidence, Mrs. Baker said she didn't think there was anything wrong with her hearing in the period 2000 to 2003, but in 2003 her partner complained that she kept putting the TV up, and she saw an advert about deafness that mentioned the Simpson Rise and Low factory, so she made inquiries. And, my Lords, that is a feature of this litigation, is that the claimants were all responding to advertisements by solicitors, or at least those who were going to provide solicitors with work, to make claims. And, my Lords, there are other references at bundle page 565, paragraph 159.
Is it not in the nature of hearing loss that very frequently those who suffer from it are not aware of it until it is brought to their attention?
My Lords, I don't for a moment go behind that. My Lords, it is worthy of note that Mrs. Baker had been 2 or 3 years out of employment, an employment that had lasted 18 years, without, by her own admission, having noticed anything. My Lords, at paragraph...
So what issue does this go to?
Well, my Lord, it comes to this, my Lord, if your Lordships are considering the application of Section 29 and considering the common law, and if insofar as there is a policy element to that, I put it no higher than that, it is not a situation, my Lords, where there is some clear wrong. There are subjects, the subject of a clear wrong, clamouring to have their wrong righted. It is right that your Lordships should know. What your Lordships make of this is a matter for this court. It can be dismissed or it can be held to be important. But it is a fact that this litigation was prompted not by grievously injured people clamouring for that wrong to be righted, but by an advertising campaign for claims to be brought.
Seems to me very much peripheral.
Well, my Lord, I take your Lordship's point. Lord, the result in Mrs. Baker's case was a finding of slight hearing loss, and that's already been referred to by my learner from Mr. Beloff in his submissions. My Lords, for the reference to that, it's at 582 in core bundle 2, paragraphs 192 and 193. My Lords, I don't make my submissions in a way that is intended to be discourteous or dismissive, but it is a relevant factor. For instance, as taken account of by Lord Justice Judge, as he was, in the Armstrong case dealing with vibration, that the relative severity of injury is a factor to be borne in mind. My Lords, that is what I say about the factual aspects, both as to the development of what eventually became the noise at work regulations and as to Mrs. Baker's individual case. My Lords, I'm conscious of the time and will spend no more than a minute or two simply identifying the relevant parts of the written case which deal with the common law issue. Lords, the written case at paragraphs 160 to 198, that is to say of the first appellant, and it's tab 5 of core bundle 1, internal pages 43 to 53 makes 4 points. Firstly, a point about interpretation of the judge's finding at paragraph 87, and then secondly, thirdly and fourthly, 3 clearly substituted findings. When I say clearly substituted findings, clear examples in my respectful submission where on analysis the Court of Appeal has simply substituted its own subjective judgment for that of the trial judge. My Lords,
On the first point, do you get anything out of anywhere else in the judgment except paragraph 87 about the cut-off or the starting date when steps should have been taken? You've got in paragraph 87 2 references by the end of the 1980s, and then you've got the reference to certainly until the times when the 86 directive became generally known in the consultative document of 87. No, is there anything more?
Well, that is it.
That's it.
Well, what the appellants say is that the judgment, what he said, which was in the 1970s and 1980s, the code of practice was indicative of what should be done and declaratory of what should have been done, and by the end of the 1980s, as he put it. And my Lord, I respectfully submit that Lady Justice Janet Smith was wrong to take the mere reference to certainly by 1987 as somehow undermining the judge's clear finding that the code of practice was determinative.
Yes, it's simply what underlining during the 70s and 80s.
Lord, yes. And my Lord, if the one thing that I would add to that would be if your Lordship sees how the judge dealt with the 87 consultation paper in the judgment itself, my Lord, the reference for that is paragraphs 39 to 41. The judge did not, other than identifying him in the narrative, he certainly did not in the substance of the judgment indicate that he felt that this was some sort of seminal change. They're related in the narrative, but it is, in respectful submission, the Court of Appeal erred in placing so much weight, in placing any weight, on the mere reference, certainly by the end of 1987.
What was the paragraph references?
I'm sorry, my Lord.
Paragraph references to how he dealt with the consultation paper?
Lord, yes, that's at 39 to 41.
39 to 41, thank you. Yes.
Core 2, page 503. My Lord, as for substituted findings, my learned friend Mr. Belloff has identified the legal principles. They are trite law, and my Lords, I cannot really improve on the distillation in the written case. My Lord, the error may come from the fact, and I say this with some deference and diffidence, that common law was dealt with, quote, very briefly, and the fixing, for instance, of the first appellants whom I represent with knowledge in 1983, based merely upon one witness's awareness of a debate, not a conclusion, a debate, in a paragraph that lasts no more than 9 lines, represents the Court of Appeal, if I may say, with respect, indulging in enforcing its own impression in preference to that of the judge.
Which paragraph was that in particular?
My Lords, that's in 109 of the Court of Appeal judgment. Lord, that's the second substituted finding that those whom my learned friends and I represent had knowledge in 1983. My Lords, to rely on what one witness said was merely an awareness of a debate. It is wrong to fix a company with knowledge on that basis. My Lord, the other, as I say, the other provisions, the other aspects of that argument rather speak for themselves. My Lords, there's a causation point raised, but it's right at the end of the argument, and it is there for your Lordships to consider. Lord Alex.
What just a matter of interest, what were you asking us to do with the causation point?
Well, my Lord, that is a difficulty, my Lords. The case before the Court of First Instance was clearly and unequivocally, whatever one may see in the written case, that all that was required of the defendants to discharge their duty was to make hearing protection available and give advice as to its use. There was, my understanding, and others, each side of me had the advantage of having been in the case at first instance and before the Court of Appeal. But my understanding is that no specific evidence was adduced from Mrs. Baker that she would have worn voluntary hearing protection. I make it absolutely clear to the court that it's accepted that she did when it was provided, but her evidence about that was that she believed it was compulsory, and the date for that was 1989. Lord, it's safe to say
that would be a somewhat Pyrrhic victory to win on that one point.
Well, my Lord, we have better points.
The inference from the judge, judgment is presumably that he thought that she would have worn it, otherwise he wouldn't have.
My Lord, one might reach that conclusion. My Lord, we have better points in this case.
Thank you. Well, we shall look forward to Mr. Purchase tomorrow morning. 10 o'clock, yes.